Hey, Death Money students. So this week's units are all about the law. So you're going to be reading about the laws that make certain crimes capital crimes, like aggravated murder, for example, as a death penalty crime. It's death eligible in all the states that have it, the federal government, and the military as well. What I'm most interested, though, however, is the Supreme Court cases that have decided, number one, whether the death penalty is legal, and number two, under what conditions it's legal. So you're going to be reading an article that I wrote with Dr. Simon in our department before she retired about the issue of consistency and inconsistency in the court over time with regard to death penalty cases. Now you also have a PowerPoint slideshow as well, that pertains to that. So I'm going to get into some of those details, but do your readings from the Death Penalty Information Center first, then do the reading of the paper. And that's what one of your writing assignments is going to be about this week. And so you're going to see what we call, Dr. Simon and I call the Big Four. These are the four cases that decided, first of all, whether the death penalty is considered constitutional in the United States. That answer is yes. And then how capital punishment must be carried out in the United States. So these are called guided discretion laws. I've talked about this before. Juries are given guidance by law about which murderers should live and which murderers should die. And that's in the form of aggravation and mitigation factors. So aggravating factors listed by statute, and I've encouraged you to read the ones in the North Carolina General statutes, which I've provided links to for you, or you can search it online. They're listed by law. They say these are the things that make a murder worse, like having committed another murder, or particularly atrocious and cruel murder, or a murder involving torture and that sort of thing. And then there's mitigating factors that make murders worse. Okay, like so someone coerced you, or the victim was one of the defendants, or it's the first time you've done it. These are mitigating factors that are established by law. Okay, and so to sentence someone to death, a jury has to find that the aggravating factors outweigh on the scale the mitigating factors, and then the judge can impose a death sentence if it's recommended by the jury. Okay, and then the third thing these cases decided is under what circumstances aggravated murders can be executed. It can't be mandatory. Can't kill them all. So these are the things that these cases decided. They also decided that even overwhelming evidence of racial disparities in death sentences within a state do not prove discrimination. Hence, we still have the death penalty. I'll explain that as we go forward. Okay, so look, we're going to go through 4 cases. You're going to read about 4 cases. You're going to read what the justices wrote in these cases, what the courts held. And the reason this is important is because it will help you understand why the death penalty is still legal in spite of clear evidence of serious problems with it. That's what reading these cases helps you understand. Okay, so the first case is Furman versus Georgia. This is the longest ever Supreme Court decision ever handed down at the time. And it's considered by some scholars to be the worst decision the court ever made. I don't know if I agree with that. Read about the case details. I describe the type of crime. I describe the person accused of the crime. The likelihood that this person would not get a death sentence is nearly zero. Okay. The ruling, however, was 5-4 that the death penalty was cruel and unusual punishment in violation of the 8th and 14th Amendments. Try to follow. This is what the Supreme Court asserted. Death sentences were arbitrary, random, freakishly random, very infrequent, almost like getting struck by lightning, and selectively against minorities. Now, you have to understand, I'm not saying I agree or disagree with it, but the Supreme Court had literally presented no evidence, statistical evidence, that the death penalty was racially biased. Let's say it was. Okay. But the point is there was no evidence. This becomes important later when we go through the rest of the cases. But they found that arbitrary sentencing, random sentencing, violates the Constitution because it often leads to infrequent and unfair punishment against one group of people over another. So this ruling voided the death penalty in 40 states, 40 jurisdictions. and 629 death sentences were overturned. So these people had their life sentence or death sentences commuted to things like life or long periods of incarceration. Okay. Now you read what the justices said individually. They argued that arbitrary punishment is a violation of the Equal Protection Clause. We are guaranteed, for example, under the 14th Amendment, for equal protection, and we're all treated the same. So that's the main argument. But other justices, like Justice Brennan, raised a really interesting point that becomes part of death penalty lore and death penalty case law, that the death penalty does not comport with human dignity, that it degrades us, especially when it's arbitrary and excessive. We'll get back to that issue as we go through the other cases. The other really important opinion in Furman is the Marshall opinion, because Justice Marshall put forth what he first called, or what it was for the first time that he put forth this idea of what became called the Marshall hypothesis. He said it doesn't matter if people support the death penalty. It matters if they would support it if they knew the facts about it. So this became the Marshall hypothesis that he later stated in Gregg versus Georgia, the next case, that I should say he stated it again, okay, became more clear. This is the argument that people support the death penalty in theory, but when they learn the facts of the death penalty, the way it's actually applied, they're less likely to support it. This is something that we'll end up with in the class looking at death penalty opinion, and we'll see there's actually a lot of evidence that's true from different studies, including some of my own in my classes. But the basic majority here, 5-4, was that the death penalty was arbitrary and therefore unconstitutional. Now you have true conservatives on the court like Rehnquist, who using conservative constitutional principles like judicial restraint and separation of powers said this is not a court issue. Judges are not activists. We don't strike down things that states impose and that states view are valid and that the public supports. Okay, so like Justice Berger said, it's not a court issue to decide. This is something that is up to the people through their state representatives to decide. And they said arbitrariness is irrelevant if the death penalty is observed. Okay. Now Justice Blackmun becomes a real major thorn in the side of abolitionists because he said the death penalty serves no useful purpose. There's no reason to have it, but it's not up to the court. Now he becomes a problem later because he acknowledges later in his career that we should have abolished the death penalty, that we just can't get it right no matter what we do. It just has these serious problems. But he decided not to abolish it later in the case of McCluskey versus Clint. You'll see. You'll see. Okay, so first major problem and the first inconsistency is that this ruling in Furman versus Georgia in 1972 is inconsistent with the ruling the same court had a year earlier in 1971, McGotha versus California, which held 6-3 that jury discretion, unchecked jury discretion was acceptable. And Justices Stewart and White were on the court at the time, and they ruled that unfettered jury discretion in cases was not unconstitutional. And the very next year, they changed their minds and said the death penalty was unconstitutional as a result of arbitrary sentencing. This is the type of inconsistency that you'll see, okay? But in terms of the Furman case, it did not declare the death penalty itself unconstitutional. So look, the Fifth Amendment says you shall not be deprived of your life or your liberty or your property without due process of law, which means you can be deprived of your life if there is due process of law. So the death penalty itself was not ruled unconstitutional, just the way it was being applied. Well, states didn't just give up. 36 states adopted new death penalty statutes. 1/3 of those, like North Carolina, adopted mandatory statutes and said, look, fine, if you're convicted of capital murder, you're sentenced to death, period. Jury has no discretion. Others adopted what became the law, the new guided discretion statutes, where juries were given guidance about who lives and who dies. And those are the ones that were actually upheld later, as you'll see. So Woodson versus North Carolina, 1976, is the Supreme Court case in our state that struck down mandatory death sentences. So read the description of the case. Again, it describes who did the crime, how they were convicted, what they did. And the court ruled 5-4 that the death penalty mandatory was cruel and unusual punishment in violation of the 8th and 14th Amendments, okay? Number one, mandatory death sentences violate respect for human life because they don't give jury guidance. Juries are vital to American justice, right? They're the backbone to protect us from arbitrary, overzealous prosecution, right? They protect us from the government. And they noted that society has actually moved away from mandatory sentences. They even noted importantly that mandatory sentences don't remove arbitrariness. In other words, randomness in the death penalty is not eliminated by mandatory sentences because look, the prosecution doesn't seek a death penalty. That's still arbitrary. That's up to them. So there can still be random or arbitrary death sentences within the prosecutor's office. But some of the justices, when you read the case, they'll say things like juries were refusing to convict in mandatory death sentence cases. They wanted to have discretion, and that juries don't even impose the death sentence on most murderers, so we can't make it mandatory. Justice Marshall said that this was not acceptable to an informed public. That's the Marshall hypothesis again. And then Brennan, again, was more philosophical and was just talking about the death penalty is just degrading the human life. So he's just an opponent of the death penalty. Where the other justices said that arbitrary sentences were just not possible under mandatory death sentences, and that it was supported by the public, so it should stay in place. But nevertheless, it was struck down. What was upheld the very same year was the guided discretion laws in the case of Gregg versus Georgia, and this was 7-2. So finally, it's not a 5-4 decision. Guided discretion statutes were constitutional because they provide guidance to juries about who should live and who should die. Here's the key. The Supreme Court held that arbitrary sentences were no longer possible now that juries were given guidance. Furthermore, you had what's called bifurcated trials in states like North Carolina, and in this case, come out of Georgia. Bifurcated trial means the first trial is to determine your guilt. The second one is to determine your sentence. This protects a defendant from arbitrariness. You also get an automatic appeal to the state Supreme Court if you're sentenced to death. This protects the defendant. You also get a proportionality review of your sentence where the courts look at your sentence to make sure that it's not excessive based on the nature of the crime and what others convicted of that crime are sentenced to. These are all, this is called super due process, extra due process protections for death penalty defendants. So back it up a minute. In the case of Furman versus Georgia in 1972, the death penalty was struck down because of the possibility of arbitrary, random, discriminatory sentence, even though they had no evidence or presented no evidence that that was true. 4 years later, the Supreme Court reinstates the death penalty because these fixes supposedly made it where arbitrary, random, discriminatory sentences were no longer possible without any evidence that it fixed it. So here's the court making two major decisions without any evidence to say whether or not there was a problem in the first place and whether or not these fixes corrected it. That becomes important later when we look at the last case. So the major argument in the Gregg case was that arbitrary sentences were no longer possible, even though there was no evidence that it fixed the problem. But the argument was that with the mandated review of the sentence and juries given the option of a lesser sentence with guidance, legal guidance, that arbitrariness is no longer possible. So discrimination is no longer possible, according to the court. Justice Brennan said that the death penalty just degrades human dignity, and it's the court's responsibility to regulate morality. So he's just the death penalty opponent, right, no matter what. Justice Marshall, again, posed what became known as the Marshall hypothesis. Doesn't matter what the public supports, it matters what they would support if they knew the truth about the death penalty. The argument is that the truth about the death penalty is pretty ugly. Americans don't support convicting the innocent. Americans don't support racial bias. Americans don't support arbitrary sentencing. If they knew that, they would turn against the death penalty, which is actually what's starting to happen in the past 10 years. Now, here comes the key case. So, the first case, Furman, the court strikes down the death penalty because of the possibility of arbitrary and discriminatory sentence, even though they present no evidence of that. 4 years later, in Gregg versus Georgia, they reinstate the death penalty, the Supreme Court does, because of all these fixes that are put into the law, which they say makes arbitrary, random, discriminatory sentencing impossible. They present no evidence that it's fixed the problem. Okay, here comes McCleskey versus Kemp, 1987. Read the case. Okay, a race effect is determined. So, sociologist by the name of Baldus does this big study. where they measure hundreds of things, and he uses a technique called multiple regression, where you can hold different variables constant in order to determine the effect of one variable on death sentences, and that variable is race. So does race affect death sentences in the state of Georgia, even after controlling for things like how serious the murder was? So they're holding those things constant with multiple regression. They were able to determine with statistical evidence that the death penalty in Georgia was arbitrary and discriminatory against black people, as well as people who killed white people, killers of whites. So this is the first demonstration of the race of victim bias, that the death penalty is being used against killers of whites. The Supreme Court ruled 5-4 that statistical evidence of disparity was not enough to overturn the death penalty. To overturn the death penalty, the individual has to prove that they, as an individual, were discriminated against by race, or the legislature intended for them to be discriminated against. This is impossible, right? You read this case, it's amazing. The court says disparities are an inevitable part of sentencing. This is the Supreme Court that struck down the death penalty for the possibility of arbitrary sentencing. Now they're saying arbitrary sentencing disparities are inevitable, and they even said, if you read it, things like, I bet we could show that different facial features might correlate with death sentences. That doesn't mean we're discriminating against people based on the shape of their face. Pretty amazing, isn't it? To kind of correlate or relate facial features to race, like it's the same thing. Like, oh, it's just random, like maybe hair color or nose size or whatever also correlates. But look, this is the South with a history of racial discrimination. And here you have scientific evidence of racial discrimination, and the court says this is not enough to violate this Constitution. So the majority holds, including Justice Powell, holds that disparity is not discrimination. Intentional discrimination is required. They also held this is not a court issue. Now, the 4 justices of the minority said arbitrary sentences have finally been proven. The very thing that you struck down in Furman versus Georgia has been proven. And this proves that the fixes that were approved by the court in Gregg versus Georgia in 1976 are not working. So you're violating your own precedent. You're violating your own reasoning. So it violates Furman because of a substantial risk of arbitrary sentencing. It violates Gregg because a pattern of arbitrary sentencing would be unconstitutional. And Justice Powell wrote in Furman, he said, this type of disparity might be constitutional. He said, these are his words, if a Negro, this is the term at the time, if an African American, a black person, could prove that members of his race or color were being singled out, that might raise to a constitutional violation. Well, here's the evidence coming that they were being singled out or targeted, and he ruled that's not enough. Disparity is not enough to prove discrimination. So this case is inconsistent with rulings on other cases of discrimination. So, for example, women have sued saying they're not being paid the same as men successfully in courts. They don't have to prove they're discriminated against individually. They just have to prove that women are, and that disparities are enough in unemployment cases and things like that. The dissent claimed that the court is putting its faith in fixes that obviously don't work. And they note that, the pattern of racial disparities in the capital cases are made up of individual cases. So where do those disparities come from? They come from discriminatory acts by individual members. So we know that prosecutors often abuse their discretion. We know that juries do too. So we know that they seek and impose the death penalty more when the victim's white, especially when the offender's not. Pull up the information from the Death Penalty Information Center. In interracial cases where a murder is committed between colors, between races, we have far more black people executed for killing whites than we do whites for killing blacks. It's not even close. And this is evidence of discriminatory intent on the part of either prosecutors and or juries. This is being ignored by the court. Now, the last part of the paper in the presentation deals with the inconsistencies in the decision. So you pull up the tables from the paper and in the PowerPoint presentation, and you'll see how individual justices change their minds over time or change their reasoning over time. So I would call your attention to Justice White from Furman to McCleskey. So In Furman, he ruled that the death penalty was unconstitutional because of the possibility of arbitrary sentencing. And then, some 15 years later, in the case of McCleskey versus Kemp, Justice White sides with the majority that disparities, arbitrary sentences based on race is not enough to strike down the death penalty. That's inconsistent, right? That's just one example. You look at Justice Powell and Furman, who ruled to uphold the death penalty in Furman, despite the possibility of arbitrary sentencing. And then, did I say Powell? Yeah. Then he rules with favoring retention, even when there's arbitrary sentencing proven. The reason, another example is the reasoning in McCleskey is different than Batson versus Kentucky. If you guys are CJ majors, you look up Batson versus Kentucky, where it deals with jury selection. Prosecutors are not allowed to strike down people from a jury just because of their color. And if they do that, let's say a prosecutor eliminates a black person from a jury, a defense attorney can challenge that. And if a judge says, yeah, why are you doing this? Then the prosecutor has to come up with another possible legal reason why, a legally acceptable reason why they're eliminating African Americans from jury. Just individual disparities are not permissible when it comes to jury selection, but disparities are permissible when it comes to death penalty cases. Like death is different for some reason. So look at those differences. Now, what you're going to see in the paper is 3 types of inconsistency in Supreme Court. Okay. Let me start with the third one. The third type of inconsistency is just when a court violates its own precedent, which you saw in these cases. But you'll also see it with in the death penalty. In the 1980s, the Supreme Court said it was permissible to execute people who had mental retardation or cognitive, what we now call cognitive or intellectual disabilities. Some 20 plus years later, the Supreme Court ruled that unconstitutional. In the 1980s, the Supreme Court said it was permissible to execute juveniles, people who are 16 and 17 years old, who commit murder. So 20 plus years later, the Supreme Court overturned that, said it was not constitutional. This is a type 3 inconsistency, violating a precedent, overturning its own precedent. Now, in those 2 cases, the Supreme Court overturned their own precedent because state laws changed. An overwhelming number of states started abolishing those practices, and public opinion turned against them. And so the Supreme Court said, oh, this violates human decency. Remember that from Justice Brennan, where our evolving standards of decency change over time. So the meaning of cruel and unusual punishment in the 8th Amendment changes over time. So that's maybe more permissible. The other types of inconsistency, type 1 and type 2, are harder to understand or justify. So type 1 is where an individual justice issues an opinion contradictory to an opinion they issued in a different case. Type 2 is where they issue an opinion contradictory to statements they made in an earlier case. So you know the difference between holding and dicta, right? Holding is the actual decision of the case. So type 1 is where one judge's holding is different in one case than it is in another. Type 2 is the dicta is just the statements they make as part of their written decision. So if a justice says something, like if an individual member of a race can demonstrate that they're being targeted for differential punishment, and then later when that fact is established in the court, they don't uphold that as unconstitutional, that would be type 2 inconsistency. So you go through and you'll see lots of different examples in the paper of these types of inconsistency. And the final part of the paper tries to explain why these inconsistencies happen. What you'll see is part of this comes about because of the ambiguous nature of the Constitution itself. So cruel and unusual, for example, is not defined in the Constitution. Okay, but you also see, obviously, that justices change over time on the court. So the court's rulings are going to change when you have new justices. Our evolving human standards change. How we view things as either cruel and unusual or not changes over time. And that's indicated by, as I said, public opinion and state legislative activity when states are abolishing things, for example. It sort of clues the court in on what we consider to be okay and what's not okay constitutionally. But more disturbing is politics. So Democrats, presidents, tend to nominate people on the Supreme Court who are more in line with democratic values or more liberal. And if they're confirmed by the Supreme Court, then they sit on the court. And Republican presidents tend to nominate people whose ideology is more Republican or conservative. And if they're confirmed by the Senate, they're on the court. What we see is that the political party of the appointee and their political attitude, their ideology affects their ruling. They approach and interpret the Constitution differently. Liberals and conservatives approach this much differently. And so that's going to affect, when they see something like a racial disparity, whether that's relevant, whether they think it's relevant or important, depends on whether they're conservative or liberal. Whether it actually impacts their decision, whether they think the court should get involved, is a function of their political ideology. So, for example, liberals tend to get more involved and think the court has a job to regulate morality, whereas conservatives think that's not a court issue, and that's up to state legislatures to do. We'll take something like racial discrimination in the South, right? Should the courts get involved, or should they let the state legislatures make the decisions? If the state legislatures have racial bias, or if people in the South have racial bias, shouldn't the courts get involved? But what if the courts do get involved and the people in the South or in those states or on those juries get upset about it? Don't they think the court has overreached? This is why it's a challenging bunch of issues to decide, right? But what you notice in the Supreme Court with these cases most fundamentally is that, number one, the death penalty was upheld as constitutional in theory. Number two, the death penalty was struck down because of the possibility of arbitrary sentencing, even though arbitrary sentencing was not proven. It was reinstated, number three, after states changed the law to make arbitrary sentencing impossible without evidence of arbitrary sentencing, that it fixed it, okay? And number four, when arbitrary sentencing was proven statistically, the Supreme Court still allowed the death penalty to continue, even knowing about racial disparities and potential racial biases in the death penalty. So as you'll see going forward, we still have arbitrary sentencing in the death penalty. We still have racial bias in the death penalty. Race of victim bias is demonstrated in nearly every state where it's been studied, as you'll see as we move on. Why is it legal then? Now you know, because the court has not been convinced that that means a constitutional violation, okay? They're not convinced it violates the 8th and 14th Amendments to the U.S. Constitution. All right, that was a quick explanation of those cases. Please read them. Go through the PowerPoint slides, read the cases, read the article, and then if you have questions, email me, talk about it on the forum together, and if you'd like to Zoom individually, I'm happy to do that, or as a group as well. Just let me know, and enjoy it. I mean, this is fascinating stuff and a fascinating time. Be safe from the virus, be safe from the protests, be safe from the police. You know, there's stuff going on out there, right? And keep reading and let me know if you have questions. All right, peace.